start, the undue influence which will vitiate the will must be such as operates upon the mind of a testator at the time he executes the will, and thus controls and induces him to make the will in the manner in which he does by reason of that influence. It must be such influence as affects the free agency of the testator and impels him to yield his choice to the person exerting the influence. Acts of kindness, disparaging statements of one who is the natural object of the testator's affection, and bounty in general will not constitute undue influence, but if these operate on the mind of the testator at the time of making the will so as to place him under any restraint and control the terms of the will, they may amount to undue influence. It is not necessary that the undue influence be exerted by a beneficiary under the will, neither is it essential that the undue influence be exerted at the time of the execution of the will, but the undue influence that will vitiate a will may be the sum of total of the effect of words spoken and acts done at or prior to the time of executing the will, but the effect of the acts must operate upon the mind of the testator in the act of making his will and restrain his free agency at that very time. Otherwise, the influence does not affect or void the will. Para. As stated, a person of full age, sound mind, and memory, and not under any restraint, may dispose of his property or parts thereof by will, executed according to law, provided his disposition does not violate any law. The testator has a right to decide the terms of his will. He has a right to select the persons to whom he gives his property. He determines the portion he devises or bequeaths to each. He judges the fairness, justness, or quality of his disposition by will. As its provisions affect others, no one may question his right so to do or challenge his will if made according to law and its provisions do not violate the law. The contents of the will, the effect and consequences of his provisions upon the persons whom the testator would naturally bestow his affections and his estate, as apparent from the evidence submitted, may be considered in connection with all the evidence in determining whether the testator did possesses testamentary capacity or was under restraint at the time of making the will when he did make it. Over.